I'm Stephen Mayson, Professor of Strategy and Director of the Legal Services Institute at the College of Law. I've spent probably the last 7 years thinking about where this market goes and the particular opportunities that David Clementi wanted, what we now call ABSs, to bring to the marketplace. So I've spent a lot of time thinking about the issues, talking to the people who might want to take advantage of these opportunities. I think I understand it pretty well. An alternative business structure is a particular creation of the Legal Services Act. It requires some fundamental things to be in place. So first of all, it has to have somebody in it as a manager who isn't a lawyer. It has to deliver at least one of the 6 reserved legal activities. It has to have a lawyer who is an authorised head of legal practice who reports to the regulator about the ABS's activities, and it has to have an approved head of finance and administration as well. They're the structural requirements. What an ABS is, frankly, is just a wrapper for any way in which you might want to deliver legal services on their own, or combinations of legal services and other activities. Might be a state agency, might be accounting, might be something not connected with professional services at all. So I would just see it as a different wrapper. It just has statutory requirements that you've got to go through in order to get that wrapper. The reserved activities are rights of audience, rights to conduct litigation, what are known as the reserved instrument activities, which many people say is conveyancing, but it's not that broad. It's the preparation of the contract or the instrument of transfer of real property. Probate activities, which again is not the whole of probate or the administration of estates, simply the preparation of the grant of probate or the letters of administration. Notarial activities and the administration of oaths. It could be either. A lot depends on which way they choose to go with it. I think the first point to make is that the opportunities for ABS that are open to people who aren't lawyers are equally open to lawyers, with the exception that you can't have a lawyer-only ABS. But that apart, it's a level playing field in terms of opportunity. Where it might not be so good for lawyers is if, through the ABS mechanism, we get much larger branded providers with deep pockets, much better understanding of customer relationships, customer loyalty, how to sell, how clients want to buy, and they use that power to drive very much larger businesses than even large law firms are today. And I think that would be an unlevel playing field, but that'll be a consequence of somebody taking advantage of opportunities in different ways. So I think we start pretty much at the same point. We might end up in a very different situation where some law firms are successful and some will probably find they've lost some of their core business. At one level, it's quite difficult to see how professional bodies, particularly the representative arms of the professional bodies, can do much at all to protect the profession. Certainly the regulators would say it's not their job to protect the profession, it is their job to protect the delivery of legal services that are consistent with ethical obligations and legal obligations that clients require. What the representative bodies can do, I think, is either help those businesses that want to take advantage of the new opportunities to do so, and help those that don't want to take advantage of those opportunities, at least to position themselves in a better way to withstand the sort of competition they might now face from possibly bigger and better organised and better financed businesses. But the problem for the representative bodies is that their members are likely to cross the whole spectrum of those who benefit and those who don't. So it's somewhat difficult to take a position and say we only want to protect lawyers from other forms of ABS, when actually some of their members will want to be those other forms of ABS. I'm not sure there's any particular structure that's at risk, although you might argue that the traditional professional partnership is an ill-equipped vehicle to cope with some of the changes we might be looking at. Probably the vulnerability is going to lie in the nature of the work that a firm does rather than what structure it happens to have. And the sort of work that I think is going to be most at risk is what we broadly describe as retail or consumer legal services, so conveyancing, will writing, probate, probably a bit of employment and personal injury work, which is the staple of a lot of smaller firms and indeed some of the larger ones. And that, I think, is where the commercial opportunities lie, to do things differently, particularly to do them at scale and to drive economies of scale in ways that law firms haven't so far. I think the first thing firms need to do is understand where their business comes from at the moment, because a large part of what we're looking at is who's going to control access to work, particularly if it's volume work in the retail legal marketplace. So understanding where you get your work and why you get it at the moment, for me, is going to be key to working out how likely it is that you're going to continue to get work from those same sources. Because if the sources change, the odds are the effects on you are going to change. So it's understanding where the work comes from, and then, as a result of that, saying, do we need to change? And if we do, how do we need to change? And it's probable that the change will either be merging or consolidating with other smaller providers, so you present a bigger critical mass to a volume buying market, or possibly becoming part of one of the new branded providers to support them in their delivery, because they'll be the ones who control the work and how it gets divided out amongst law firms, and maybe you're just going to choose to join them rather than fight them. I don't think anybody can really predict. We just don't know exactly what is going to happen. And that's probably why we hear a lot of practitioners saying, well, you know, we've had a lot of change before, there's been a lot of hype, there have been expressions of doom and gloom, but nothing fundamentally has changed, so why should we worry this time? I think the difference is this time the real opportunities are going to fall to those outside the profession, and they won't be bound by history or professional structures that we've had for very many years. They will look at things differently and they'll do things differently. 10 years ago we didn't have Co-op providing legal services, or AA or Saga or Which or Halifax. We've got them now, and some of those are businesses in their own right that would get into the top 100 of law firms by turnover if we measured them in that way. So I think it's difficult to say nothing will change, because things already have changed. And for me, it's inconceivable that there won't be more change and more development and probably more encroachment on traditional law firm territory.